and welcome to Workplace Wednesdays. My name is Elisa Blakers and I'm an associate in the Labour and Employment team here in Sydney. As many of you know, we have quite a unique entitlement in Australia called long service leave, which is a period of paid leave for an employee who has been working with the same employer for an extended period of time. But what happens when an employee transfers within a company to Australia? Is their overseas service counted for the purposes of long service leave? This is typically quite a vexed question for employers in Australia, as the answer is often not easily ascertainable. There are cases where an employee serving only around 20% of their total service with the group company in Australia have still been found to have an entitlement to long service leave. A recent judgment has provided some clarity on this, with the Victorian Court of Appeal finding that 2 employees who were initially engaged in India and then transferred to Victoria are not entitled to long service leave under the Long Service Leave Act. At the time of resignation, both of these employees each had more than 7 years of service, which is sufficient length of service to attract an entitlement under the Victorian Long Service Leave Act. While more than 2 years of this service was in Victoria, upon their termination, the employees did not receive a payment in lieu of long service leave. It was determined that the reference to 7 years of continuous employment with one employer in the Victorian Act means continuous employment with one employer in and of Victoria. Accordingly, given the employee's employment in India had no connection with Victoria, that service did not form part of their continuous service. However, the court did note that in and of Victoria can extend beyond circumstances where an employee's service with the employer is in Victoria. So, for example, this may include not only employment performed inside Victoria, but also in obedience of a direction emanating from Victoria. So, for example, while on an international secondment. This ruling will hopefully give some comfort to global employers with a mobile workforce, or at least those based in Victoria. Employers should consider and remember always that long service leave legislation is state specific, and while this case may influence the position in other Australian states and territories, it was determined under the Victorian legislation. We would recommend that employers seek specific advice as to whether an Australian-based employee's prior overseas service does count for the purposes of their long service leave entitlements. Thank you for tuning in to Workplace Wednesdays.